એટલે તમે લખી શકો. ઓકે, એટલે પતી ગયું.
Good evening, ladies and gentlemen. I, Nishant Lalekya, on behalf of Justice P.D. Desai Memorial Lecture Committee and trustees of Brilliant Public Charitable Trust, welcome you all to this 16th Justice P.D. Desai Memorial Lecture on the topic Criticism of Judiciary, Contempt Jurisdiction, and its use in the age of social media. Before we get started with today's function, as per our tradition, we shall begin with a prayer. May I request Mr. Amar Bhatt to recite to us Mahatma Gandhi's as well as Justice P.D. Desai's favorite prayer.
ईशावास्यमिदं सर्वं यत् किञ्च जगत्यां जगत् तेन त्यक्तेन भुजिथाः मा गृधत् कस्य स्विद्धनम् साधो सहज समाधि भली साधो सहज समाधि भली गुरु प्रताप जादिन तेजा की दिन दिन अधिक चली साधो सहज समाधि भली जहाँ जहाँ डोलो सोई परिक्रमा जो कुछ करो सो सेवा जहाँ जहाँ डोलो सोई परिक्रमा जो कुछ करो सो सेवा जब सो करो दंडवत पूजो और न देवा साधो सहज समाधि भली कहे कबीर यह उन मुनि रहनी सो परगट कर गाए कहे कबीर यह उन मुनि रहनी सो परगट कर गाए दुख सुख से कोई परे परम पद तेहि पद रहा समाई साधो सहज समाधि भली गुरु प्रताप जादिन तेजा की दिन दिन अधिक चली साधो सहज समाधि भली ओ
Thank you so much, sir. Thank you. May I now request Sri Suresh Selath, Senior Advocate, to formally introduce and welcome our esteemed speaker for tonight.
Good evening, everybody. Distinguished guest, Harish Bhai Salve, Honorable the Chief Justice Vikram Nath, Honorable Justice M.R. Shah, Judge Supreme Court of India, Honorable Judges of the High Court of Gujarat, Justice C.K. Thakkar, Sri Tushar Bhai Mehta, Solicitor General, our guardian Kalpesh Bhai Javeri, members of legal fraternity, students from Nirma University, GLNS University, and GNLU University, directors, professors, and teachers from these universities. It's a matter of great pleasure and privilege to welcome you all this evening at the 16th P.D. Desai Memorial Lecture organized under the auspices of Praleen Public Charitable Trust and the Lecture Committee. The Praleen Public Charitable Trust was founded by a great and eminent judge, Sri Prabodh Bhai, who lived his life as an example for all of us. He worked hard, lived economically all throughout his life, and left his heritage for the future upliftment of weaker sections and for the legal fraternity. His sterling qualities endeared him to all of us, and endearment was coupled with great regard and reverence. The Trust is organizing every year a memorial lecture in his honor. We also organize seminars on the recent subjects, which can be discussed by our junior members of the college. Last year, we had opportunity to have Dr. Justice Chandrachud on the subject, the hues that are India from plurality to pluralism. The Trust has for the upliftment of village Kharagoda, which is Agaria's village. We have provided there potable water, which was not available till then. You will be surprised to know that in Ahmedabad, SLU Women College, associated and affiliated with the SNDT University, does not have sanitation facility or fire safety equipment. We tried to help them and give them better. And the trust has provided handsome amount for buying machine at the General Hospital for X-ray at Adivasi village nearby. We are fortunate to have eminent advocate of our country this evening. We are grateful to him for having accepted our invitation. Salve was born on 26th of June 1956 after graduating in commerce from Nagpur University. Studied law and chartered accountancy simultaneously. His father was an eminent chartered accountant. It was Sri Palkhiwala who inspired Salve to take up the study of law. He soon lost his interest in accountancy and became interested in tax matters. His interest grew deeper and he decided that if he wanted to practice taxation, then he should opt to become a lawyer. In 1978, he decided to go to Delhi while setting up his practice at the Supreme Court. He was designated as senior advocate in 1992. Harish took over as the Solicitor General of India in 1999. He was only 43 at that time and held his office till 2002. He decided to join London's Blackstone Chambers to become an English barrister. He was called to join Gray's Inn, one of 4 London inns of courts that barristers are required to join before they can practice before courts. Senior and Harish Salve was awarded Padma Bhushan, which is the highest professional, third highest decoration. Harish Salve is simple and modest at heart, but a thorough professional as well. The perfect role model for budding young lawyers. For him, professionals are all students of law and can and are entitled to make mistakes. Mistakes are not bad. Dedication and sincerity are the most important attributes that a professional can have, according to him. As a lawyer, he is par excellent and has been ranked amongst the most powerful person in the country today. Salve was conferred with Padma Bhushan in 2015. His contribution to the development of taxation law, commercial law, and constitutional law is immense. In the recent past, he represented our country before the International Court of Justice for Kulbhushan Jadhav, who has been arbitrarily treated by Pakistani courts. He firmly believes that a modern lawyer has to be a lean, mean, fighting machine, a service provider, par excellence, well trained in area of specialty. The subject chosen by him is criticism of judiciary, contempt jurisdiction, and its use in the age of social media. To quote from appeal cases, Privy Council opined in Andre Paul versus Attorney General. But whether the authority and position of individual judge or the due administration of justice is concerned, no wrong is committed by any member of the public who exercises his ordinary right of criticizing in good faith, in private or public, the public act done in the seat of justice. The path of criticism is a public way. The wrong-headed are permitted to err therein provided that members of the public abstain from imputing improper motives to those taking part in the administration of justice and are genuinely exercising a right of criticism and not acting in malice or attempting to impair the administration of justice. They are immune. Justice is not cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken comment of ordinary man. This webinar will provide you an opportunity to listen to our distinguished guests from the comfort of your home. I request Sri Salve to share his thoughts on the subject. Thank you.
It's an honor to request Mr. Harish Salve to enlighten us on today's topic, criticism of judiciary, contempt jurisdiction, and its use in the age of social media.
Good evening, or should I say good afternoon from London. Justice Shah, Judge of the Supreme Court, Chief Justice and judges of the Gujarat High Court. I see Justice Thakur is here. Mr. Kamal Trivedi, Advocate General, a dear old friend. Shri Shelat, another very eminent colleague and a dear friend. Colleagues from the judges of the High Court, colleagues from the bar, and young friends. I am deeply honored that Shri Shelat has invited me today to share some ideas and some thoughts with you on a subject which for some reason has again found itself on the center stage in our country. Mr. Shelat asked me whether I would like to speak on criticism of the judiciary or I would like to speak on contempt of court. And I said, how about combining the two subjects? Because in present times, the two appear to have been joined at the hip, as they say. And in exchanging ideas on this subject gives one an idea, gives one an opportunity to sit back and see where we are, see what shape society has taken, see what role today the different institutions have come to play and how different they are from the time of their birth. How do we adapt old principles to new circumstances? And how do we work towards creating a rubric of constitutional principles, a body of law which serves democracy best, which serves governance best, which helps us achieve the virtues which our founding fathers set out to achieve by writing the Constitution of India. Equality and the dimensions of equality today recognized internationally, such as transparency, accountability, and subserving the cause of rule of law. Somewhere along the way, we seem to forget that the courts are meant to serve the cause of rule of law, not just to decide cases which grab headlines. And in the ultimate analysis, the strength of an institution comes from the faith of the people, and the faith of the people in an institution depends not just on the occasional sparklers which come out of the court, but on how well it serves the people in achieving what is the fundamental role ascribed to the institution. It's a strange world we are all living in. I don't think on 16th of January 2020, somebody had said, will you give a speech in Gujarat in the memory of the man who was an institution in himself, Justice P.D. Desai. I would have ever thought that this speech would be delivered staring at a computer screen and would be heard through speakers by guests sitting at different places and looking at a computer screen. While the gates of all our homes are locked, especially in this part of the world, there is a serious lockdown in place. But the world has changed, and we have survived the year. And hopefully the end of this trauma is in sight. The world is a different place today. And recent events have established similar problems plague institutions all over the world. India, contrary to the critics who like running down India, I always feel India, if you look at the big picture, has evolved as a great republic. I do not ever remember there being any tension in the country where one prime minister gave way to another. Unlike the world's richest democracy today, which is facing riots on the transition of a head of state. Who could have thought that in United Kingdom, the English courts, known for their conservative hands-off approach, would interfere with the decision of a prime minister to prorogue parliament and direct that the session of parliament be continued. So yes, the world is a different place. All of us in democracies have similar problems. And therefore we gain a lot by looking around us, seeing how other countries have dealt with problems, without forgetting that ultimately the solutions we find have to match our ethos and have to serve the cause of achieving the same objectives of transparency, of good governance, but in the social milieu in which we find ourselves in India. One thing of which we can justifiably be proud is the way democracy has prospered over the decades. I remember in a speech once, Mr. Palkhiwala, who was a trenchant critic of the government, somebody asked him, sir, do you say democracy has failed? He said, when did I ever say that? And the answer he gave was telling. He says, we have changed, and this was in the early 80s. He says, we have changed 4 governments with the ballot, not the bullet. You are free. He said, I am free to come into this hall and criticize the most powerful prime minister in the world. We have a judiciary which is robustly independent. And we have a parliament which makes laws in public. He says, look around us. How many countries can boast of these virtues? And this, in one sense, is the essence of democracy. So we have done wonderfully well in evolving. No democracy has been free of problems. So yes, in the course of governing 1.3 billion people in a country ridden by poverty. We have had our problems. But the fact that we have managed to keep democracy not just alive, but on the move and keep it evolving, I think has been a great success. And one of the things which has been a matter of great success in India is the recognition of speech in all its dimensions. We have recognized free speech not just as a privilege of the few who are protected, who have access to means and who can protect themselves. We have nurtured the right to free speech in its correct spirit. Not only that, we have expanded the right to free speech to extend to the right to know and use that as the linchpin of developing principles of transparency. Through this route, we have injected transparency into the Indian constitutional ethos. And it's a matter of great pride, one can say, of the rule of law itself, that such principles, once they take root, become impossible to dislodge. No government today can dream of repealing the Right to Information Act, inconvenient as it may be to those in government. No government today can think of curtailing speech. The government has been struggling for years to find ways of reining in social media and is unable to do so for the simple reason governments today have in their heart been driven to accept that democracy is not negotiable. And I think that by itself, reaching this point in governance, that democracy is not negotiable, has itself been a great advance for India. In this evolution of democracy, while you have free speech, which has moved ahead, we have the courts which have evolved. I always say the turning point was the Krishnairization of Indian jurisprudence. Professor Bakshi used to say it was the Supreme Court of India. Justice Krishna Iyer made it the Supreme Court for Indians. And that turn, that identity which he gave to the court and to Indian jurisprudence has helped the Supreme Court and the courts, the constitutional courts, the Supreme Court and then the high courts, to evolve from dispute resolution tribunals to institutions of governance. It's a matter of pride that our courts have evolved into an institution that an average citizen considers as an institution of governance where he can go to vindicate his basic rights, not just to resolve his disputes. And I think that has been a very positive development. The second is that the courts have evolved into institutions which are willing to test the larger constitutional underpinnings, not just constitutional validity, but the larger constitutional underpinnings of important decisions that affect the country, that affect its people. Be it the problem of migrant labor, be it the problems of farmer protest, be it the problems relating to curtailment of media, be it the problems relating to droughts, be it the problems relating to remedial work post-earthquake. In all areas, our courts have been in the forefront, examining the constitutional underpinnings, not just the constitutional validity and constitutional challenges, but the constitutional underpinnings of governance. And this has been a great march forward. With this march forward, necessarily comes the inevitable criticism. The criticism may stem for a step too far or a step too short, or both. And so far, a criticism of the court of what the court does has today been accepted as if attribute of a free society. Where then do we draw the lines? Do we need lines? Do we need principles of contempt? If we do need principles of contempt, where do we draw the lines? The lines must be drawn in a way that the overall system of governance, the institutions and the criticism of the institutions, helps everybody march forward in this march of democracy. There's a famous story Mr. Pilu Modi recites in his book called My Friend Zulfi. Zulfikar Bhutto was a great friend of Pilu Modi. They were together in college in England. And when Bhutto was lying in jail in a trial which is publicly now acknowledged as being a complete farce, where he had been sentenced to death and he was finally executed, he's supposed to have written a letter to Mr. Pilu Modi, in which he says, Pilu, I've always been critical of what I call the dust and din of Indian democracy. He says, today when I lie in this dark, quiet cell, I now realize the value of the dust and din of a democracy. So the dust and din of democracy serves a huge purpose in keeping institutions in check. We have to, however, make sure that we evolve principles that they don't become, that this din doesn't become counterproductive and reaches a stage where it starts impairing the working of the institutions. The law of contempt, like a lot of laws which have evolved into great principles, has very dubious origins. The law of contempt was evolved back in the day by the courts, where the court and the king were one. And the kings did not take too kindly to people not acceding to their jurisdiction and readily threw people in jail. The hated Star Chambers generously used to use the power of contempt of bringing people to book. And contempt at that time was a form of assertion of authority by the king and the king's judges over the citizenry. And even the criminal contempt principle was used for very strange purposes. There's a very interesting story in Arnold's book on contempt where he quotes that in 1397, a court had issued a writ. Here issuing a mandatory injunction is called a writ. The court had issued a writ not to maintain a quarrel. And the person who was asked not to maintain the quarrel went and fought nonetheless. And so he was thrown in jail for committing a breach of the writ issued by the court. And they called it criminal contempt because he said this brings this administration of justice into disrepute. A thin excuse to throw somebody into jail. So this is where it was born. But then a lot of these important principles have been born in dubious origins. Magna Carta, as we all know, was actually the charter written to protect barons from the judges. But the principles which were incorporated in the Magna Carta have formed the basis for creating a whole charter of liberty. So out of these principles evolved some very important principles by which the modern courts have administered justice. And I don't think anybody challenges assertion by the courts of the might of the state when it comes to compelling the obedience of their orders. In 1971, we know Lord Hailsham had set up what's called the Fillmore Committee after the problems of pre-publication and newspaper comments on ongoing trials had reached a point where the court felt it was interfering with the administration of justice. In the famous case, it's known as the thalidomide case, where some distilleries who were producing thalidomide were asked to provide compensation to those whom they had affected, and the matter was pending in Court of Appeal. The Sunday Times ran a series of articles. That was held to be contempt by the Court of Appeal. Lord Reed, whose democratic credentials can never be doubted and whose sense of justice and sense of restraint cannot be doubted, he said in those days that if people are led to think that it is easy to find the truth, disrespect for the process of law would follow. And if mass media are allowed to judge, unpopular people and unpopular causes will fare badly. When I was reading this the other day, while preparing this speech, I remembered this passage. And I said, can we apply this to some of the recent coverage we have seen of criminal trials where electronic channels take unto themselves to become the investigator, the accuser, the complainant, the investigator, the prosecutor, and the judge, and pass judgment every evening on a TV in the presence of 5 or 6 jurors called panelists, who each distinguish themselves by being completely unfamiliar with the subject on which they comment. Despite what appears to be the apparent wisdom of Lord Reed, the Fillmore Committee found this to be too harsh because they were so concerned that this test, which the House of Lords in that case, in the thalidomide case, had set out, was too vague. They said this is too wide, it will scuttle criticism. And that is why the Fillmore Committee came up with the test of serious risk that the course of justice might be interfered with. The second important principle, and I think that is something which we need to bear in mind, is, however, the Fillmore Committee accepted, and that is one thing which is recognized, that there is no notion of a justifiable contempt. It's an oxymoron. Either there is, if a comment is justified, there is no contempt. If a comment is within the extremely wide canvas which is available for critical comments, there is no contempt. But if you have gone past that canvas, then there is no notion of something being justifiable contempt. We talk of contempt, criminal contempt as we understand it, having almost disappeared. And that's correct. The principle of what is called scandalizing the court has almost become obsolete. In fact, Lord Justice Simon Brown in one judgment said very interestingly, declining to exercise contempt jurisdiction, that when personal allegations are made, a wry smile is our usual response. The more extravagant the allegations, the more ludicrous they sound. And I think, or Lord Ackner said, whenever we have new judges, he says, my advice to them is grin and bear it. So, by and large, judges have, over the years, evolved a very robust attitude where they do not let this kind of criticism affect their work. I'm sure it bothers you as human beings when people talk nonsense about you. But it's a part of the job to grin and bear it. Indian judges have shown similar resilience, and Justice Sabyasachi Mukherjee, late Justice Sabyasachi Mukherjee's decision in the Shiv Shankar case is a eloquent testimony to how robust our Supreme Court is, where he said, we treat it with contempt, not in contempt. So the system has developed the strength to deal with this kind of criticism. Scandalizing the court, therefore, is something which has almost fallen into disuse. But there is something which we need to remind ourselves. Protecting judges, protecting the institution are no longer considered the philosophical underpinnings of the law of contempt. But what happens where it becomes necessary for the judges to deal firmly to protect public faith in the institution? As Lord Denning said, we will never use the power of contempt to protect our own dignity. It must rest on surer foundations. But what happens where it becomes necessary to protect public faith? And there we have to realize, can we, without careful scrutiny, borrow the developments which may have taken place in other jurisdictions? And to what extent do we learn from them? We today have accepted that judges, or rather courts, and especially constitutional courts, have become institutions of governance. As an institution of governance, it must be open to public scrutiny and public criticism. Mr. Shaler mentioned about justice not being a cloistered virtue. Today, it's far more. Governance has to be under the sharp blaze of sunlight. Far from being cloistered, governance has to be under intense scrutiny. Otherwise, democracy is in peril. Secrecy in governance has no place. In fact, I think a time may come where the Supreme Court may consider seriously a very large number of provisions of the Official Secrets Act. How far do they square with democracy? Most of them have fallen into disuse. So on the one hand, you have institutions which have evolved into institutions of governance and must therefore ex hypothesi be subject to rigorous scrutiny and intense continuous debate, no less than parliaments or houses of legislature. The second problem is the width of the discussion. We have always accepted that the decisions of courts can be criticized, including in language which may be impolite. So the decisions can be criticized. Can we criticize the decision-making process? Why not? Can we not criticize haven't we heard a criticism of laws made by Parliament saying this was passed in a hurry? Have we not heard a criticism saying this should have been referred to a select committee or should have had 3 more readings? Greater care should have been bestowed in passing a law which has such far-reaching consequences. There should have been a greater degree of cohesion. There should have been an attempt to create a consensus. Haven't we heard these criticisms? Now, that doesn't criticize the decision, i.e. the law. That criticizes the decision-making process. Why can we not criticize the decision-making process of the co-equal constitutional institutions, the courts? Of course we can. How far do we go? Can we not ask why certain cases were heard in a certain way? Of course we can. Why is it so particular that the courts hear cases in public? Because justice is administered under public gaze. That makes the decision-making process subject to public scrutiny. We don't have this problem in India, but in the UK, very commonly you have applications for secrecy, for conducting proceedings involving commercial matters or proceedings involving certain kinds of domestic disputes in secrecy. And if you see or certain bankruptcy proceedings which may have reputational issues, and the English courts are loath to order secrecy unless it is found to be of compelling need. Because even in matters involving personal issues, the courts say primarily delivery of justice has to be in public and under public gaze. So are we entitled to criticize a decision-making process? Yes. Are we entitled to criticize a slant? And this word slant I don't use in a pejorative sense. Do all of us not have can't helps? Some of us believe strongly in the virtues of open society. Some of us believe strongly in the virtues of conservative society. Some of us strongly believe in the virtues of an open, free economy. Some of us strongly believe in a welfare economy of the socialist model. Do we completely shed that when we get into a court? We don't. Haven't we always had judges who we say at the bar, oh, so-and-so is a pro-citizen judge, so-and-so is a pro-government judge? Now, that is not a criticism of a judge. It's a mindset which you bring to bear. And that is human, because we are all human when we sit there. Are you not entitled to criticize that? Of course you are. Where do we draw the line? And that is the question which we have to consider in 2 or 3 contexts. One of the contexts is who is rendering that criticism. If there is a tweet by a lay person, and today judges work under the intense gaze of those who have nothing better to do than to sit with a mobile phone in their hand and pass judgment, especially on things which they don't understand. Should we take even cognizance of those comments? We should not. The wry smile, grin and bear it. But a criticism by politicians, that raises different issues. There's a very interesting article. In 2015, there was a case where sentencing by the courts, by the Court of Appeal in Australia, of people convicted of a terrorist attack in Victoria were criticized. And while the case was still pending, the ministers made a statement saying judges are soft on terrorism. The kind of language we don't find unfamiliar in India. And contempt proceedings were initiated. And there was a very interesting debate. While the judges found it prima facie a matter of contempt, the author of this article said, if you are dealing with a matter of public moment, i.e. sentencing terrorists, why should those who are in a co-equal branch of government not have the right to criticize you? Does that undermine public confidence in the judicial institution? No, it does not. So I think what we need to recognize what is not done is to today treat the judges as sitting in ivory towers who nobody can say anything bad about. And if you want to speak about a judge or a judgment, you speak in hushed tones. That is no longer the test. In fact, Michael Kirby, who used to be the Chief Justice of the Australian High Court, wrote a very interesting article in which he gave 3 or 4 instances. One of them was that the Lord Chancellor, in a speech in the House of Lords given in June 96, referred to unprecedented antagonism occasioned as a major clash over the distinct roles of Parliament's ministers and judges. And he condemned what he called the judicial invasion of the legislature's turf. And he reminded the judges to go back and pick up their book of Desai to remind themselves of the absolute supremacy of the British Parliament. The kind of debate we have heard in India also. But this is a positive criticism, maybe in language, which was questionable and bad taste. But the content of the criticism was within the ken of the Lord Chancellor. He gives, in fact, another example. The one newspaper article wrote that there's a sickness sweeping through the senior judiciary. It's called galloping arrogance. And went on to say that while European human rights judges from some countries, which once sent political prisoners to Siberia, are venting their spleen on Britain, legal weevils here at home are practicing their own brand of mischief. And went on to say, now it seems that any judge can take upon himself to overrule a minister, even though Parliament may have approved of the minister's action. This is to arrogate power to themselves in a manner that makes a mockery of Parliament. The judges are giving an impression that they are acting on a political agenda of their own. Now, this kind of a criticism, when it was put to the judges, they said, that's his view. But what we need to note that in cases involving matters of public moment, people in public life would criticize you. That criticism, if it pertains to a principle, cannot be considered scandalizing the court. The relationship between the organs of governance is written on shifting sands. Haven't we seen cases which in the 60s the court would say we don't have any jurisdiction to entertain are freely entertained today? Who knows, in 2040, the court may go back to a more conservative stance. Constitutional law is not static, it grows. In fact, I heard a very interesting expression. He's retired now, Lord Sumption. Lord Sumption used to be one of the finest silks in UK. He was directly elevated to the UK Supreme Court. So he once gave a speech on one subject where he said, the law in UK develops crab-like. It takes one step forward, one step left, one step right, one step backward, then one step forward. So that's how constitutional law evolves. But that's the beauty of the system, because judges don't race ahead. They realize the consequences of what they are laying down are so far reaching that it's always a baby step at a time. And the fact that they are willing to take that step sideways or a step back shows the strength of the system. They do not become prisoners of an error. Now, how can this be achieved unless you are criticized? So criticism of judges, criticism of what is called judicial overreach, criticism of the manner of functioning is not scandalizing the court. And language in which criticism is addressed should always be treated with a wry smile. Where do we then draw the line, or do we throw the principle of scandalizing the court into the dustbin? There is one area where I think judges need to be protected. And that area is casting aspersions on an institution inconsistent with its character as an independent institution. You can say that a judge or a judgment or a group of judges who have delivered a judgment have thrown to the winds the limitations on the power of the judiciary. You may use strong language, but ultimately what you're saying is that they have misread their own jurisdiction, which is a criticism which is completely open. Now, as a lawyer, you might say that this transgresses the principles of restraint, or this transgresses the principles of not taking cases which cannot, or deciding issues which cannot be decided by judicially manageable standards, etc. We as constitutional lawyers have all these mantras. A layperson may say that you are jumping into somebody else's stuff. Stay within your own four walls. So language doesn't hurt, but if the criticism ultimately comes down to a thing of overreach, you may say, why have you granted bail? You are becoming over liberal. You may say, why are you not granting bail? Have you judges lost your soul? But to say you granted bail because you came under, or refused bail because you were acting under pressure of the government, that attacks the foundation of your institution. If the institution is to be the bulwark against executive tyranny, to say you're acting at the behest of the executive undermines public confidence. That scandalizes public faith. It doesn't scandalize a court, it doesn't scandalize a judge. To say an institution has lost its independence, to say that an institution is acting at the behest of somebody, to allege corruption, that, if it is established to be untrue is clearly undermining public faith. What does the future hold for us? Should we throw away the principle of scandalizing the court, or should we keep it? I think, and this is my personal view, I don't think in India we have reached that stage of maturity in our society where people have the restraint of keeping this line in view. People have the maturity to understand what is a ludicrous allegation. And it's instances which are few and far between. And obviously, the court will see who is the person who is making the allegation. An allegation made by somebody who is a non-entity may perhaps be not treated with as much seriousness as an allegation made with a person who is capable of swaying publicly. A disgruntled litigant always gets angry. There's a famous story Mr. Parasaran narrates, where in the 60s, a litigant was going out of court and he got so angry in court one. He turned around, he took out his slipper and he hurled it to the Chief Justice. I think Gajendra Gadkar was Chief Justice that time. And Justice Gajendra Gadkar told his staff, please return his slipper. He has lost his case. I don't want him to lose his slipper also. That's how you treat problems like this. So a disgruntled litigant, of course, will make statements. But if the disgruntled litigant is a minister of the government and he makes a statement which suggests that the courts acted out of anything less than honest motive, he can say you got it horribly wrong. It can say judges are allowing their political philosophy to come in. But if he says that the judges have acted out of favor or out of fear, that undermines public faith. When you are sworn into office, you say, I will do my duty without fear of favor. If you are acting under fear of the executive or if you are doing a favor to the executive, and if a person of substance makes that criticism, he better make it good. I don't think we are ready for doing away with that. How do we strengthen our systems is another story. It's perhaps for another day that we will debate. How do we correct the process of appointment of judges so that there is greater public faith in the people we have who are appointed? We have some very fine judges. It's not a question of who are judges. It's a question of how the public sees them being appointed. There are other ways of strengthening our institution. A transparent process of appointment in which lay people will be involved as much as those who are in the profession will refresh the institution. It will not be an institution perpetuating itself. But that's for another day and for another debate. These are the ways in which we can strengthen public perception. And who knows, over a period of time, we have seen Indian democracy mature. We have seen Indian democracy grow. And today, I think we can say without fear of contradiction that the Supreme Court and the High Courts are viewed by the average citizen with a great degree of respect. If it wasn't so, you would not be flooded in the Supreme Court and in the High Court day in and day out with public interest litigation, with people coming to you, putting their faith in you. The ultimate test of public faith is the kind of work which reaches you. And I think that should be the greatest comfort to a judge, saying whatever some dilettante may say, look at those who are coming to us, with what faith they are coming to us, and with what sanctity they are treating our institution. But yes, this residuum of power to deal with those who are capable of influencing public opinion. You may be in public life, you may be an influencer, you may be a person who is in a position, you may not be in a government position, but you may be in a position where people respect you hugely and look upon your views not at that I've learned this new expression, I believe they are called the average Twitterati, not as that, but look upon you as a person who knows what he's talking about. I think those are cases where the court must retain with itself this slender jurisdiction of addressing any rupture in public faith which may be caused. We owe it as members of the bar to protect our institution. It breaks my heart when I see judges being criticized, courts being criticized, and members of the bar not responding to it. There is a very interesting thing which happened 4 days back. Mr. David Perry, who's a very eminent silk, has been requested by the Hong Kong administration to prosecute the 4 people who have been charged with offenses under the new Security Act for sedition and anti-national activities. And all the people in Hong Kong, the liberals in Hong Kong, started attacking this person, saying, how can you, such an eminent criminal silk of the UK, come and take up the cause of the government? These people are pro-democracy and pro this. Lord Panic, David Panic, very proud to belong to a chambers where he is. Lord Panic wrote a very interesting reply to this criticism in a letter to the Times, where he pointed out that this gentleman is a very eminent lawyer, and in fact it is necessary to have a lawyer with a strong moral structure to prosecute in a case like this, to make sure that he brings home the prosecution with fairness, not with a sense of vindictiveness. So in fact, you should welcome the fact that a person of such eminence has been appointed as a prosecutor. And then he added, he says, those of us who belong to the system owe it to deal with ill-informed criticism. I can never forget an allegation was made, Justice Kapadia, and I say so publicly, Justice Kapadia decided a case, environmental case in the Lanjabar mines, where for the first time he directed how monies should be paid by a mine owner and put in a special purpose vehicle and used for the local people, etc. He decided that case in open court after a number of hearings, the bar committee hearing a whole battery of lawyers. And his decision was called corrupt by somebody who appeared before him, because he rejected the argument that it's a tribal area and no mining should be allowed. And that decision was called corrupt. And I remember he almost had tears in his eyes one day. He was sitting in court number 3 that time. He almost had tears in his eyes. And he said, we are called corrupt, and you members of the bar do nothing about it. I was so upset. In my own name, the only time I have done so in my life, I moved a contempt petition, which is still floundering in the Supreme Court, I'm sorry to say. But just 14 years. But this is something which we owe to the judges. We owe to the judges for the simple reason we are part of the same institution. It is true the court cannot reply to ill-informed criticism, but it is equally true and very important to remember that we as a part of the system must deal with ill-informed criticism. Ill-informed criticism should not be quelled using the power of contempt. Ill-informed criticism should be killed by the bar. And we owe it to correct debate if it goes wrong. I have no doubt in my mind, and especially when I have younger friends, I openly confess our generation has failed in me, but I have great faith in the next generation. And I see these youngsters who come out of law colleges, I see their enthusiasm, I see their integrity, and I see their passion. And when I see that, I know our institutions will evolve, we will get past these problems. And somebody else who will give a similar speech 20 years later will say, scandalizing the court is a principle which now is in what is called the ash heap of history. Thank you.
Thank you so much, sir. Thank you so much for your very enlightening and thought-provoking speech. May I now request Mr. Kamal Trivedi, Advocate General, to deliver the vote of thanks.
Our today's esteemed speaker, Senior Advocate and Queen's Counsel, Sri Harish Salve, Honorable Mr. Justice M.R. Shah, Judge, Supreme Court of India, Honorable Mr. Justice Vikram Nath, Chief Justice, High Court of Gujarat, present as well as former Honorable Judges of the High Court of Gujarat and Supreme Court of India, Honorable Mr. Justice K.S. Javeri, former Chief Justice, Orissa High Court, and the inspirational soul behind Prabodh Bhai Parivar, respected trustees of Praveen Public Charitable Trust, members of Prabodh Bhai Parivar, and my colleagues in Justice P.D. Desai Memorial Lecture Committee, and the distinguished gathering of lawyers, senior advocates, student friends, and invited guests. Very good evening to all. It is indeed heartening to see that even during this pandemic, we are in a position to have this 16th Justice P.D. Desai Memorial Lecture held virtually, whereby we have got together under the auspices of Praveen Public Charitable Trust, founded by late Justice P.D. Desai, whose memory always serves as a beacon light for all of us. It's my privilege to propose a vote of thanks today. Let me at the outset, on behalf of Praveen Public Charitable Trust and Justice P.D. Desai Memorial Lecture Committee, take this opportunity to sincerely thank our today's guest, Sri Harish Salve, for spending valuable time out of his busy schedule in London. Sir, your thought-inspiring address on today's topic of this memorial lecture was really stimulating and has enlightened our minds. As I reflect on today's lecture, a funny story comes to my mind, which I would like to share with the audience gathering. Once a person named Mr. John was issued a traffic summons for which he had to take the day off on the stipulated day to appear in court. He reached on time, but he had to wait for a couple of hours for his case to be taken up. And in the process, he got increasingly restless. Finally, late in the afternoon, his case was called out. He stood before the judge, only to hear that court would be adjourned until the next day and he would have to return. Mr. John yelled at the judge, "What? What for?" The judge, equally irritated by a tedious day, roared, "That will be $20 for contempt of court. That's what for." Noticing Mr. John checking his wallet, the judge remarked, "That's all right. You don't have to pay right now." To this, Mr. John replied, "Oh, I am just trying to find out if I have enough for 2 more words." Therefore, somebody has rightly said, and Mr. Salve very vividly described, that in every court proceedings, there should be a Lakshman Rekha, which should not be crossed by anyone. In this behalf, let me quote the observations of the Honorable Supreme Court in case of Narmada Bachao Andolan versus Union of India, reported in 1999, Volume 8, Supreme Court Cases, page 308, wherein I was privileged to assist none other than Sri Harish Salve, who had represented the state of Gujarat. I quote, "The right of criticizing a judgment of the court cannot be exercised with malice or by attempting to impair the administration of justice. Maybe the parties were overzealous in projecting their point of view on the matter inviting large segment of tribal population. But they should not have given to themselves the liberty of acting in objectionable manner. While recording our disapproval of the statements that are complained of, we are not inclined to take action in contempt because the court's shoulders are broad enough to shrug off their comments, and because the focus should not shift from resettlement and rehabilitation of the oustees. I unquote. Before I proceed further, I sincerely feel that our state is always full of gratitude for what Sri Salve did in case of Sardar Sarovar Dam. It was Sri Salve who induced and shared, if I may say so, a great brainwave, which was readily accepted by the Supreme Court for appointment of late Justice P.D. Desai as a grievance redressal authority, and passed on the baton to me for persuading Sri Prabodh Bhai for accepting this assignment. Ultimately, after the successive certifications by the grievance redressal authority, we saw the progressive increase in the height of the dam, pari passu with the resettlement and rehabilitation of Narmada oustees. Coming back to various references given by Mr. Salve in his illuminating address, and what I like the most, whether the criticism should be a step too far or a step too short or to both. I must say, in the dynamic digital era, social media is a turf that presents a whole new ball game in the area of contempt jurisdiction. Social media has developed a double-edged sword. Sri Salve has succinctly explained that the expression of opinions on social platforms, a characteristic exercise of freedom of expression, has been pitted against the exercise of contempt jurisdiction on various occasions in the past, and the most recent examples being that of a stand-up comedian, Mr. Kunal Kamra, and comic artist, Ms. Rachita Taneja. Netizens have the right to express their opinion or bona fide criticism. However, the situation is made complex with widespread social media trials determining what is fair and unfair and what should be the outcome of a particular case. Unfortunately, these trials create immense pressure on the judicial authorities, as was referred to by Mr. Salve. Undeniably, the freedom of speech and expression is a pillar of democracy. However, unfettered exercise of freedom may hinder and substantially interfere with the administration of justice. Thus, in post-internet stage, law needs to develop and catch up to cater to the peculiar dilemma so that a delicate balance can be struck between the exercise of freedom of speech on one hand and protecting the dignity of the judicial system on the other. Our esteemed speaker has provided enough thoughts on today's topic to be brooded over by us hereafter. Once again, our sincere gratitude to Sri Salve for having accepted our invitation to inspire all of us by his very thought-provoking lecture. As I conclude, I would like to make a special mention about Justice Kalpesh Bhai Javeri as well as Shri Suresh Bhai Shelat for being strong pillars in arranging this memorial lecture. I would also like to thank the volunteers who have worked behind the scenes for making today's virtual program a great success. Special thanks to our trustee, Shri Amar Bhai Bhatt, for rendition of a prayer, very beautiful, and to Shri Nishad Lalakia for comparing today's program. My sincere thanks to our august audience for joining and being a part of this event. Thank you very much.
Thank you, everyone. I think it is time we can all leave the meeting. Thank you.